for Mima Obibiara Aquaba at the Entra Sonko Ena Emma Obibiara. Nimdia news Ena Wasun Egusu. Yes, Emeno, Yemonra and Semino Emo.
What's the strategy of the former Chief Justice in going to seek filing an application at the High Court to challenge her removal as the judge at the Supreme Court?
Well, okay, thank you. I think, I don't know, I haven't listened into the program, so I don't know who and who are there. But if you have some lawyers around, I think they do know that what happened was an administrative tribunal to which this matter was referred. Article 146 allows the or invests power in the president, having received a petition for removal and having established a first case with the Council of State, who set up a committee of inquiry who introduced the to confirm that it worked. The prima determination that they had made. And so that committee is an administrative body. Under Article 23, they were acting not as judges, because as we know, there were only 2 judges, the rest were all laymen. So being administrative bodies and administrative officials, their actions can always be subject to judicial review, and the High Court has jurisdiction to deal with such matters. That is why the Justice chose to go to the High Court and not necessarily to the Supreme Court. I hear some people talking about Supreme Court. Supreme Court is for interpretation, and interpretation comes in only when you are not sure of the words used. In other words, if the constitutional provisions are ambiguous, they are subject to more or 2 or more interpretations, then you want to go to the Supreme Court, which has the sole authority to clarify what they think that provision means. Otherwise, as was stated many years ago in the country, so long as the law, the constitution is also a law of this land, it can be applied as when they are appropriate. You don't need every time to go to Supreme Court. Again, in the event that the High Court judge finds that the what is being called upon to deal with amounts to an interpretation, he has the right to refer the matter to the Supreme Court itself. So, to me, what has been done is proper to see whether they acted in accordance with law. After all, we have the substantive justice and we also have procedural. So if when somebody says I have not been given a hearing, we are not going to the substance. All they want to establish is that you took a decision against me without necessarily giving me a hearing. That is more procedural, not necessarily a substantive matter. Now, she has continued to say everywhere that she has never been shown what the so-called prima facie determination was all about. Look, if we talk of prima facie, you are saying on the strength of it, we find that you have committed some wrongs. Now we set up a committee. What do you think the committee would do? It is for the committee to confirm whether or not what the head at first blush is correct, or to deny, to say that no, these things were well explained during the hearing, and therefore they no longer form any grounds for which anybody can say that this person ought to be removed. So when the committee is set up, it is to act in accordance with law. It should not be on its own. And the woman, the teachers said, show me the prima facie determination that you allegedly made in which areas, so that I prepare to come and give my testimony. They refuse. Give me a copy of the petition, he refused. That the petition which was sent to the Chief Justice was also not given. Right.
But Mr. Otu, please, but the former Chief Justice appeared before the committee to give her side of the story, even though she was not given a copy of the prima facie case that the Council of State established against her.
What is wrong with that?
I'm just asking for clarity.
But that is what I said. That while she was there, she kept complaining. And they kept doing whatever they wanted to do. So at the end of the process, because they kept saying that it is incumbent, all it means is that it is only at the end of the process that you can challenge the things in the courts. Do you understand? If you are saying, if she is saying that the grounds, for example, that she might have misappropriated government funds, is not true. Because she is not a spending officer, and that the spending officer who is the judicial secretary, when the query was raised, explained everything, and the auditors became satisfied. For which reason the auditors did not capture that particular expenditure in their final management report. How then do you turn around to use it against the person that is still involved in having done something wrong? You appreciate the point I'm making. It was not a case that somebody has been charged with causing unlawful damage, but this is a case of audit. And in audit, there are steps for doing it. You don't make audit observations and get away with it, but you ask the person being audited to give you an explanation. So once the person gives you an explanation and you are satisfied with it, that ends the matter. And I'm saying that is what happened in this case. The query was raised, the explanation was given, and the final management letter came, and that matter was dropped. How do you turn around to use it? And these were all tendered, and so they were before the committee. Why didn't the committee even comment on those things that went about saying what they are saying? And you think that if somebody is saying that they may have sufficient evidence before them, they decided not to look at, and therefore we have come to the High Court. Is there anything wrong with that? Do you appreciate the point I'm making?
Yes.
And then, for example, that she had transferred somebody, and that transfer is a mistake, stated misbehavior. Where? Have you seen such a thing happen before? In your small organization, don't you make changes? I used to be there. It was is it Dr. something who was doing this program? Today I'm called and I find I saw one else who is doing the program. We make changes all the time. So if somebody has been transferred, how can this be a ground to remove a whole head of a judiciary because she has transferred somebody? Or that that went to say she should be removed for having made recommendation to the Supreme Court, and the president and the same person said there was nothing wrong with what the person has done. Is that amount to res judicata? How did they turn around to use it again against the same person? So you set up a committee to go and do a matter, and then one of the committee members sees it as a strike. That in the morning, right, that the strike is over, the battle is done. Is this person really somebody who is truthful to his oath, that he went there to work in accordance with the evidence before them? So please, to me, allow the Chief Justice to go to court to challenge whatever has happened, and then let's see what the outcome will be. After all, in Riakuto, the Supreme Court refused to say that the fundamental human rights of the detainees had in fact been breached. But today, we are praising Dr. Dankwa for having had the boldness to go to court to challenge it, and rather condemning the judges as tumultuous souls. So let us allow the process to go on and see what comes out at the end of the day. If the High Court judge before whom the case goes believes that these are matters that involve interpretation, he has every right to refer it to the Supreme Court or whatever interpretation. Finally, let me say that there are people who go about saying that the Chief Justice has so many cases in court and that is involved in a forum shopping. That is not true. In a constitutional interpretation, you don't need yourself to go to court. Any Ghanaian citizen can go to court. In the famous case of Ajetum, it was not Akwa who went to court to complain. It was somebody called Ajetum who said that the process for his removal is fraud. And in this same case, there's only one case in which the Chief Justice was involved. All the rest were not started by the Chief Justice. Individuals had gone to court. They should stop saying that she has been going about filing cases in the Supreme Court. She has only one case at the Supreme Court, and they are not even giving a hearing. They have never given a date for hearing, but they always turn around to say that their case is pending. If they want to be true to themselves, they should set dates and let's hear those important constitutional matters. Let them rule on them once and for all.
Mr. Rico, the former Chief Justice is also at the ECOWAS courts. Is that not the case?
Yes, that is true. Yes, I'm saying that nobody runs away from that. But if Ghanaian citizens have decided to go to the Supreme Court, you don't put it around their neck and say that she has got 4 or 5 cases in the Supreme Court. It is not true. She has only one case at the Supreme Court. Even the case is started, the first judicial review application, they never gave her a date until the Attorney General said he had a preliminary objection. And then when he filed his motion, that was quickly set down for hearing. On matter, no date has been given. And then they proceeded in saying that the court has no jurisdiction. How can the High Court say it has no jurisdiction over an administrative body? If that is the law they want to write, let them write it for the day 2025. Some years back, looking back, people will ask them whether they really did justice or decided to do their own thing.
But do you have a date for this new application you filed at the High Court?
Do I?
Have you been given a date? I mean, the application that the former CJ has made.
It takes a little while. You see, you have to file your process, then the other side will file their process, and then when you receive those things, you file your statement of case, then you file a statement of case, and then a date is fixed for hearing. So that this one has just started. I'm saying that in that one, when we had even filed our processes and waiting for a date, they never gave us a date until the Attorney General said they had a preliminary objection, and this motion was quickly fixed for hearing.
Thank you very much. Mimi Ayikwe Otu is lawyer for the former Chief Justice Gertrude Torkonoo. I understand lawyer Oxford is still on Zoom. Let me go to him for his final comments on this, and then we'll try and wrap it up in the studio. Right.
Thank you. Yeah. So I think let me say hello to my brother Jamtua. So my last comments before I leave the line are these comments that I need to. Once the lawyer for the Chief Justice has spoken, that is good enough. But I would say that this current application has a strong basis that has a strong basis. And one thing that we have to understand here is that, like the lawyer for the CJ mentioned, you understand, lawyers are not judges. So you really bring matters to the attention of the judge to make orders or to give reliefs. So we have to, whatever be the case, once there's a contention, you have to be to the court. So basically that's what's supposed to be. Here is the case that we are contemplating whether the separation between the provisions made in the article. But then what this specific application sought to do is to challenge the warrant issued by the president, just to say that the president has no right to remove the Chief Justice as a justice of the Superior Court. That is basically what the application is doing. We are not saying that the president doesn't have the right to remove the Chief Justice. That is the conversation for another day or what probably the lawyers will want to do again, just to see whether the procedure for the removal, as it were, by the committee were pervasive. But then this specific, I want to bring to the attention of the listeners that this specific application is to say that the president cannot remove the chief justice as a justice of the Superior Court, because if you check the warrant, it stated it. In fact, it started by saying that the provision in Article 146 is for the removal of justice of the Superior Court, before it came down to say that made reference to all the provisions and the work they have done, and then stated specifically that now the president will move Justice Torkonoo as a chief justice and the justice of Superior Court. So that is what the application is for, and that is what I want us to understand. In any case, where the previous lawyer mentioned that the gaps have been settled by the Ajay case, which I don't entirely agree, because Ajay case, I stand to be corrected, it didn't state the difference between the procedure for removal, whether or not if you remove the chief justice as a justice, the chief justice, automatically the person is removed as a justice of Superior Court. So basically, even if we get the opportunity for interpretation, these are some of the interpretative issues that the Supreme Court will probably deal with. So here, we also have to understand that Ajay case didn't address that gap. So there's opportunity for the lawyers of the Chief Justice to also kind of seek for redress in terms of that gap. And then again, bear in mind, the reason why the argument for the application is sound for me is because remember that even though the position or status of Chief Justice is provided for by the Constitution, it is administrative role. So if you remember, we have had records to believe that there were judges who were senior than most of the Chief Justices appointed, but they were bypassed. But once they were bypassed, it didn't, disqualify them, or probably didn't lose their status as justices of the Superior Court. So it gives room for the interpretation, gives room for the education, because we've had several judges who believe that they were, even some believe that they were indicted for the fact that they were due for Chief Justice, but were bypassed. So if we are trying to distinguish the administrative role from the actual status as a Chief Justice of Superior Court, then there's the need for any application to come before the High Court for judicial review, and there's the need for any other applications before the Superior Court for interpretation. So basically, that is my basis for believing that the application now is sound, and then they also have other many opportunities if they want to continue with the matter. Nobody is saying that she has not been removed as Chief Justice, of course, but the application now states that